to the testimony. At the Karen Reed retrial, prosecutors trying to shed the credibility of a defense expert. Our Dan Abrams is standing by. But first, Chief National Correspondent Matt Gutman has the latest for us. Good morning again, Matt.
Hey, good morning again, Michael. The defense team has spent much of the past couple of days trying to convince the jury that John O'Keefe wasn't rammed by Karen Reed's SUV during that blizzard in 2022, but that he was attacked at a party and mauled by a dog, a theory that at one point yesterday provided the most explosive moment of this trial.
This morning, the ferocious cross-examination of a critical witness for the defense in the Karen Reed retrial. Dr. Marie Russel, a forensic pathologist, key to establishing the defense's alternate theory, claiming that injuries on John O'Keefe's arm were not caused by Karen Reed's SUV, but by attendees of a gathering at this house, where he was allegedly dragged outside into a blizzard and mauled by a dog.
As a group, they are highly characteristic of a dog injury.
The prosecution trying to shred her credibility.
Would you agree with me that you have testified that there is no recognized methodology on diagnosing dog bite wounds?
No, I believe I said that there was no standard methodology or no standard guidelines as to how to diagnose dog bite wounds.
And posing a line of questions that turned out to be the most explosive moment of the trial.
When a dog bites a sweater, would you expect that it would leave DNA?
Yes.
The defense jumping to its feet, demanding a mistrial.
He intentionally brought up DNA. The defense moves strongly, vigorously for a mistrial with prejudice.
The judge rejecting that motion. After court, in a rough couple of days of testimony for the defense, Reed teasing the possibility of taking the stand herself.
I'm ambivalent, and by ambivalent, I could get on board with either one. I feel strongly either way.
Of course, Reed did not take the stand at her first trial. And a reminder, and I think that Dan's going to mention this in just a couple of seconds, the defense does not have to prove the dog bite theory or even a police cover-up at all. All it has to do is sow enough doubt in the minds of jurors about the prosecution's assertion that Karen Reed killed John O'Keefe with her SUV. Guys.
All right, thank you, Matt. Let's bring in ABC News Chief Legal Analyst Dan Abrams. You know, Dan, yesterday we talked. You said yesterday that the dog bite expert could be critical for the defense. How did they do on the cross-examination?
They did pretty well. I think they did a pretty effective job of undermining her credibility, but also with regard to this question of DNA. Why was there no dog DNA on the part of the sweatshirt that he was wearing where supposedly these dog bites occurred? But as Matt points out, the standard is reasonable doubt. So even if one juror is suddenly thinking, you know, it kind of made sense, or, you know, I have questions now, then that witness was a success.
Yeah, and we just heard there in Matt's story, Karen Reed said she's ambivalent about taking the stand. Will she? Should she?
There's no way she's going to take the stand. Look, in every high-profile murder case I cover, the defendants claim they either want to take the stand, they're thinking about taking the stand, their lawyers say, well, it's going to be a last-minute decision. They don't want this case to come down to, do you believe Karen Reed? They want this case to be about, has the prosecution proved its case beyond a reasonable doubt? And if she takes the stand, that changes.
Is she helping herself, though, by talking after every day to the reporter outside?
Well, look, I'll tell you, the fact that people are going to take seriously now the question of could she take the stand, it forces now, by the way, prosecutors to prepare cross-examination, to take some of their resources and focus on the possibility that she might testify. So is it smart? You know,
but the jury doesn't know whether or not she wants to testify.
Correct. But you know, often it's the lawyers saying, you know, well, we're very seriously thinking about it. So they get the other side to prep a whole cross-examination, and that means they can't focus on other things in the case. So it ends up being strategic.